Hello, and welcome to Canadian Rights Reviews, where we examine the ins and outs of Canadian rights, freedoms, laws, and policies. It's a question I have heard multiple times over the last several weeks. Can I be arrested for swearing? More specifically, can I be arrested for swearing at the police? Looking at the causing a disturbance section of the Criminal Code, that may or may not be so clear depending on your interpretation. Today's video comes to us from Auditing for Accountability NL, and was filmed inside a Newfoundland Provincial Court building. As always, links to the original video and channel are in the description.
How are you doing? How are you today, Raymond?
Name, veg.
How are you today, Raymond?
What's your name?
What's that? I'm doing an investigation story for possible publication.
Investigative.
Can I read it?
Read it. Investigative.
Oh, let me start again. I'm doing an investigative story for possible publication.
Hold on, I'm trying to omit something that don't.
No, I get to read it all.
Part of it don't. Okay, I'll let you read it all. I'll just let you know after a part of it. What's not.
Independent and only focused on sheriff's officers, police officers, probation officers, you mean?
Anybody in probation, clerks, whatever.
Like a secretary?
Anybody. That's anybody as a public official.
Politicians.
That's right.
What kind of public? Municipal?
Anybody.
Federal?
Anybody that gets paid by the
Provincial?
public dollar.
Well, that's a lot of people.
That's a lot of people, my friend.
Okay, so you're arresting all of them too. And then your picture.
Stand back 6 feet, please.
I can't see it. Hold on.
Here you
Put
go.
my glasses on. Hold on. Whoops. Glasses. Why do you make me stand back?
Because there's an order that says stay back 6 feet, isn't it?
Yeah, but you're in my face with the camera.
I'm not. You come to me.
But why are you taking people's pictures? Your picture out of.
I'm taking.
Unless stated.
That's for the public. That's not for you guys.
Okay.
I'm in public,
Yeah.
and I'm taking audio and video of public officials in the course of their duty, which is perfectly legal.
Yeah, no.
Exactly. So I don't know why you're approaching me. You're not going to come out here and intimidate me. So go back to your fucking job and move on.
No, I said hi. Yeah.
Go fuck yourself.
I said hello.
Go fuck yourself.
That's not very nice.
Hang yourself.
No. That's not
Now
very
get the
nice.
fuck out of my face.
No, I'm just.
I wish this conversation to be ended. Get out of my face.
I wish it to be ended too.
See you later. Move on.
Okay.
Boy, that escalated quickly. I mean, that really got out of hand fast.
It jumped up a notch.
It did, didn't it?
The 1992 case of R.V. Lonis is considered the leading case law in Canada, with reference to swearing related to causing a disturbance in Canada. Mr. Lonis was initially convicted of 2 counts of causing a disturbance for swearing and yelling at a neighbor in Nova Scotia. The Nova Scotia Supreme Court rejected an appeal which landed the case in the Supreme Court of Canada. The court quashed the convictions and acquittals were entered in their place. In reviewing the case, the court found 3 factors which must be present for such a conviction. 1. Was there swearing, insulting, or obscene language? 2. Did the language create an externally manifested disturbance of the public peace, in the sense of interference with the ordinary and customary use of the premises by the public? 3. If there was a disturbance, was it one that could have been reasonably foreseen in the particular circumstances of time and place? For the first factor, please note for the purpose of this video, I am focusing on language used. Being loud, shouting, or acting in other ways that may be considered disorderly, could likely make the second and third factors much easier to prove. In ruling on the Lonis case, the court held the weight of the authorities, the principles of statutory construction and policy considerations, taken together, lead me to the conclusion that the disturbance contemplated is something more than mere emotional upset. There must be an externally manifested disturbance of the public peace, in the sense of interference with the ordinary and customary use of the premises by the public. It must be present and it must be externally manifested. In accordance with the principle of legality, the disturbance must be one which may reasonably have been foreseen in the particular circumstances of time and place. There was no evidence of a disturbance of the use of the premises in question by anyone in the case. The trial judge applied a mental disturbance test, convicting on the basis that an ordinary reasonable individual would be disturbed by language of that nature being shouted in a public area. The convictions were upheld. In denying leave to appeal, the Court of Appeal agreed that language such as that used by the accused was inherently disturbing and was of itself a disturbance. There was no finding that the conduct of the complainant or anyone else was affected or disturbed by the language. In the absence of such findings, the convictions cannot stand.
Is this enough spacing?
6 feet, isn't it,
Yeah.
officer? Make sure it's 6 feet. Don't get in between it.
How can you tell?
Do you want to measure it out?
No, I'm just asking how you can tell.
Well, there's this, then you reach out. That should be more than 6 feet, shouldn't
No,
it?
I don't want to do anything that might make you feel threatened.
Oh, don't
So
worry.
I wanna
You
do
don't
this.
threaten me, my man. You don't threaten me.
You just seem really nervous.
I'm not nervous at all.
Okay.
You guys seem really nervous.
I'm not nervous. I'm
No.
just here hanging out with you. Like I
Yeah?
said.
I don't need you to hang out with me. I don't want to talk to you.
No, but I can go where I like too, right? Just like you.
No, you can't. You're on our dime. You have a job to do, not stand out here and harass the public.
I'm not harassing
You are harassing me. I didn't ask for your conversation.
You showed me your picture.
I didn't ask for your conversation. You approached me. So I told you what I was doing, so now you can move the fuck on. I don't wish to contact with you. So move on.
No, I'll just won't contact with you. I'll just.
Well, then shut the fuck up.
No, I can say what I like though too, right?
No.
I can speak.
Not when you're in a duty, and I ask you not to have a conversation with me. I do not wish to be spoken to.
Okay.
Then stop.
Our v. Lonis provides the framework. However, how has this framework been applied since this ruling? I will briefly cover a number of decisions. Links for all are provided in the description. In the 1997 British Columbia case of R. v. Moore, and the 2001 Alberta case of R. v. Daniel, the court upheld or convicted for causing a disturbance, as they found a disturbance was created, as there was an effect on others in the area. Both cases cited shouting, in addition to language used, in their decisions. In the 2009 Ontario case of R. v. Ledger, the court found incorrectly in my opinion. Mr. Ledger's attorney put forth a motion to have 3 charges dismissed. The charge for causing a disturbance was not dismissed. This was based solely on the fact that the officer testified that, Mr. Ledger saying, "Fuck you, you're a fucking asshole," to the officer, interfered with the officers dealing with Mr. Ledger's friend, which created a disturbance. Nothing other than the officer's statement was considered. It appears, in this case, the court incorrectly allowed the officer to determine what legally is or is not a disturbance, with no examination of the law. The decision found is only with respect to the motion to set aside the charges against Mr. Ledger. I could not find record showing if he was ultimately convicted. Mr. Morris was found guilty of mischief and assault in the 2005 BC case of R. v. Morris. However, his charge of causing a disturbance was dismissed, as the court found the gathered crowd was not disturbed, but rather entertained by the alleged conduct. Although there is no doubt that the defendant's attitude, tone, and words were rude, and that the police officer had every right to be offended by them. Under other circumstances they might well have caused a disturbance, but at that time and place they did not. Was the ruling in the 2006 Nova Scotia case of R. v. Williams. In the 2008 case of R. v. Osborne from Ontario, charges of causing a disturbance and assault on a police officer were dismissed. The court found that the entire situation was created by the officers approaching 2 men without probable cause, and unlawfully detaining them. Justin Cookiemuller was convicted of causing a disturbance for a loud, profane, and angry tirade at police on his own property in 2012. In 2014 the Court of Appeal set aside the verdict with the ruling of, "While I certainly do not condone yelling obscenities at the police, the issue for this court is not whether the conduct of the appellant was obnoxious or deplorable, but whether it was criminal. In my view it was not, and it follows that this appeal should be allowed, and the conviction for causing a disturbance set aside."
Casey. C. Casey. Do you have a badge number, Mr. Casey?
I thought you didn't want to converse with me.
I'm asking for identification.
No, you said you didn't want
Do
to
you
converse.
have a badge number, Mr.
Now you
Casey?
would like to converse with me.
I'm asking you a simple question.
No.
That's under policy.
You said you didn't
By
want to converse.
policy, if a member of the public asks,
I don't know who you are, if you're a member of the public or not.
actually you stated who I was. So you're the
so you
idiot
are.
that's on recording. You want to be a YouTube star, my fan?
Do you know who that guy is?
I don't give a fuck who that guy is.
Are you looking for people in that office too? Special special prosecutions office?
Absolutely. They get paid by the public dollar, don't they? You're not going to harass me, my son.
I'm not harassing you. I'm just
You're
having a
trying
chat.
to.
No,
You're
I'm
trying
not.
to intimidate, and it's
at
not
all.
going to
Not
work.
at all.
Abso-fucking-lutely,
I just
yes.
like talking to you.
I don't need you to talk to me. You had no reason to come out and
Okay.
speak to me.
Well, you're the one you were talking to me. I just
No,
wanted to make sure you're okay.
no. You approached me
Okay.
and started talking to me. I didn't approach you, sir.
I just wanna
You
make
come
sure
out
you're
to
okay.
me. You don't need to make sure I'm okay. It's not part of your duties. Your duties are only to secure this building. That's it. Not to make sure I'm okay.
You mean Atlantic Lakes?
Secure there.
What?
The courts, provincial courts.
Okay.
This is considered public access.
Yeah.
Yeah, and so is a part of in there. But if I was Fred Hutton, like I had said in there, if I was Fred Hutton or somebody else, they'd be allowed in there. You wouldn't be saying crap to them.
Well, you're an independent journalist.
It don't matter. Journalism is legal in Canada. It don't matter who it is.
Yeah, but you're allowed in there.
Exactly, but I was kicked out of there a couple of seconds ago.
Maybe you were causing a disruption.
No, I hadn't spoke a word.
You're being disruptive now.
Because you approached me when I asked you not to. He approached me when I asked him not to. Pardon? Oh my. This bottom part don't approve. The bottom part that I have covered doesn't apply to you as being a public official.
Okay, well listen now, you know you're on conditions, right? So you've got to keep it down if you're going to be sticking around here.
He
okay?
can leave me alone,
No, but you're hearing me, right?
and I'm not doing nothing wrong. I'm not doing nothing wrong.
You've got to keep it
I'm not doing, call the police.
all right.
I have it all on video. So if you'd like to call them again, that'd be great. Because they showed up at my door 2 days ago for no crime at all. That's called intimidation.
Back to our original question. Can you be arrested for swearing at police? Yes, you can. In fact, as we have seen in countless situations, if the police want to mess with you, they will find a way. The real question is, will it be prosecuted and will the charge stick in court? That answer is less clear, but overall, swearing at police alone is not a crime. A foreseeable disturbance must be created that goes beyond mere offense or emotional upset. I can say I have personally sworn at and shouted at police multiple times in my life, when I have felt they are abusing their authority. As per the previously mentioned 2008 case of R.V. Osborne, I am within my rights to do so. In cases where an abuse of authority is less clear, time, place, and manner should certainly be considered. I am going to reserve judgment on auditing for accountability NL in this case. I do not know enough about the circumstances that led up to this encounter, and clearly there is more at play. Considering time, place, and manner, I would advise caution in such cases inside a courthouse. Sheriff Casey earned a clear fail. Even if the initial approach was innocent, he stuck around to make his presence known which, at best, served to antagonize the encounter. Thank you for watching, and we hope to see you again soon.